Hello and welcome to our new video series where we are introducing our ITF partners to our members. Today it gives me pleasure to welcome Paul Foote, European and UK patent attorney at Withers and Rogers. Paul, welcome, and we look forward to hearing from you today. We'll talk about various issues affecting intellectual property protection. But first, if you could just give us a brief insight into Withers and Rogers and the services you provide.
Thank you. Yeah, so Withers and Rogers is a European firm of patent and trademark attorneys. So the main services that we provide are helping businesses get patent protection for technical innovations, trademark protection for brands and logos and names of businesses or products, and design protection for the look of products where there's usually some sort of eye appeal. So we help with the application process to get those rights registered. We can also help with enforcement of those rights if you find that somebody might be treading on your toes of your protection, and also if you're concerned about other people's protection and whether you're safe to go ahead with a particular new product or process.
Very good. And you say that these protections are UK protected, European protected, and worldwide protected?
Yeah, so we can directly do work in Europe. So we have offices in the UK, France, and Germany. So despite Brexit, which we'll come on to, we can still offer the full gamut of services in Europe. But we've also got a network of attorneys that we use in pretty much any country in the world that can help us get protection if you need it in, say, the US or in China, because it's important to recognise that all of these rights are on a country by country basis. So if you just get a UK patent, somebody can quite merrily make that product in the US, and provided they don't do anything in the UK patent's not going to help you stop them doing that. So we always need to think about the international dimension on all of these new developments.
Of course, yes. And obviously the UK went through some dramatic changes on the 1st of January 2021 at the end of transition. And I think most UK businesses have been impacted to a greater or lesser extent by Brexit, and I'm sure that the IP world it falls into that bracket as well. Obviously, there's different strands of IP protection, from patents, the trademarks, and registered designs, and I'm sure that they've all been impacted in different ways. What have been the implications of the end of transition and Brexit?
So yes, you're right, they have been impacted. I would say that the least impact, in fact, there's really not been any significant impact, is to patents. So although there's a UK intellectual property office that we deal with, and there's a European patent office that we deal with, that European patent office is not an EU body. So the fact that we've left the EU doesn't impact that system at all. We're still entitled to directly file applications on behalf of our clients in the UK at that European patent office, and the process is the same. So what happens there is you've got a new technical innovation. The European Patent Office is a sort of single body that we can submit that application to, and once they're happy that it meets the criteria of being new and inventive and so forth, they will say, yep, we're going to grant this European patent. But then you have to choose, do you want that to be brought into force in the UK, in Germany, in Sweden, France, wherever else? That system is unchanged and won't change despite a Brexit. So that's simple. It gets more complicated with trademarks and designs.
So just to finish on that point of patents, the European Patent Office, are all European countries signed up to that particular office then?
So every EU country is, plus a few others besides, including Turkey and Switzerland and the UK now, that are not part of the EU. So it's a sort of supranational agreement that isn't an EU thing.
Yeah.
And yeah, so it's fortunately for me, yeah, it's not affected because my life would be immeasurably harder if it was an EU body. I might be moving to Germany or somewhere right about now to carry on having a job. So yeah, so that's simple. Yes, but for trademarks and for designs, the situation has changed. So I'm happy to go into those in a bit more detail.
Yes, yes. If we start with trademarks.
So trademarks are just, background. They are for protecting, brand names effectively, or logos, what we call sort of badges of origin, names that, or logos, or even things like sounds in theory, that when somebody hears them or sees them are kind of connected with a particular business. So you know, Jaguar for cars, or any number of brands like that. So for more than 20 years, there has been an EU trademark that has been administered centrally by the European Union from an office in Alicante in Spain. And as a UK business, you would have a choice of going to the UK Intellectual Property Office and just getting a UK trademark registration, or going to this EU trademark office and getting a registration that would cover the whole of the EU. And for a lot of businesses, that was quite attractive because you were getting cover in 28 countries, and it was not 28 times the cost of getting a UK trademark registration. So it was an attractive route to getting very broad coverage. As of the 1st of January this year, those EU trademark registrations no longer cover the UK. So if you've got an existing EU trademark registration, it ceases to cover the UK. But as part of our withdrawal agreement, the UK government agreed that they would automatically copy over all of these registered EU trademark registrations to have an equivalent UK trademark registration. So as of sort of midnight on the 31st of December, all of these new UK trademark registrations automatically came into place that mirror all of the existing EU ones. So if you've got EU trademark registrations, you've now magically got a UK one as well that kind of fills the gap in that protection that you otherwise would have had. So that's good. It means that nobody has lost any form of trademark protection. What it does mean is when these rights have to be renewed on a sort of 10-yearly basis, you have to pay a fee every 10 years to keep them in force. You've now got to pay a fee to the EU Trademarks Office if you want to keep the 27 EU 27 registration live, and separately pay a fee to the UK Trademarks Registry, part of the UK Intellectual Property Office, to keep that UK registration alive. So ultimately, the costs are going to be higher. That's the main thing with existing ones where they've already been registered. In future, if you want to get protection for the UK and for the EU, then you've got to do that by going to both of those offices separately and getting
two separate registrations.
Yeah. Now we as a business, because we can do both of those, we can do the EU one from our office in Germany, for example. We've got a package that enables people to do that, with a streamlined process and at a kind of special rate, I would say. And there's also a mechanism if you want protection in other countries as well outside of Europe. It's called the Madrid Protocol, where there's another way of streamlining that registration if you want protection in, say, the US or other countries around the world, that we can look at on a case-by-case basis, depending on where you want that protection. The other thing to bear in mind is, if this is, you know, unlikely to be the case, but if you've got an EU trademark application that's not yet registered and is still pending at the EU trademarks office as of the 1st of January, you don't get that automatically copied over to be a UK registration, but there's a 9-month window to file a new UK trademark application and have it backdated to the date in which you filed your EU one. So sometimes dates are important. You know, if somebody else comes along and tries to register something similar in the meantime, it can be important to have an earlier date. So that's just a mechanism to.
So you have a nine-month window to register it with the UK office.
Yep.
But it will be backdated to when
Yep.
it was accepted at the European.
When it was filed at the European.
And would there be an additional cost to do that?
Unfortunately, yes. So you basically got to pay the fees as if it was a new UK trademark application from you know, without any earlier kind of application there. So the main benefit is the earlier date.
Is the backdating.
Yeah.
I see. Yeah. And just before we move on from trademarks, you say that the existing trademarks that were already registered have been cloned. I'm assuming the existing renewal date has also been cloned as well, so you get the same length of protection before renewal.
Yep, that's right. Yeah. Yeah. So that you know, there are other kind of wrinkles around it, but you know, they're mainly of interest to practitioners like me. But that's the main upshot of trademarks. So for designs, which is the other main area, there's been a similar regime of, you can get a UK design registration for the look of a product, or you can get an EU one, and there is a similar process where existing EU ones are copied over onto the UK register and will sit alongside. The difference is they're renewable every 5 years. So again, you've got to, and you're going to have to pay separately for the UK one and the EU one if you want to keep them both. And the similar regime for, if you've got a one that's pending, you can re-register it, but you've got to pay fees for that. And then going forward, you've got to take a view: do you want the UK and the EU? In which case, you've got to go to register those both at the respective offices. And you know, again, we can sort of handle that in a streamlined process. Or there's another kind of international process that's called the Hague Agreement, that enables the UK, the EU, and other countries like the US or Canada or wherever else to be kind of done with a single application process as well, that depending on where coverage is required, we can look at whether that's an applicable kind of process for doing that.
Is that separate to the European or in addition?
So what you do there is you file a single application and you designate certain countries. So you could choose, okay, for this one, I want UK, EU. I did one recently that additionally had the US and Canada, and provided everything goes through smoothly, you don't need to deal with the EU office or the US office or the Canadian office or the UK one for that matter. You just get a notification that, yep, they've been registered and it's all done. If there's a wrinkle with something, say there's a similar design in the US, we'll get notified of that, and then we might need to appoint a local US attorney to deal with that. But you know, normally when we kind of know what you need to do, and 9 times out of 10 it shouldn't be an issue, and you get that registration through fairly painlessly. The downside is it can take 6 months to a year to get that registered. So if you want something quickly in the UK and the EU, the quickest way to do that is to file directly in those two. The UK registry could take a matter of days or weeks to register, and the EU registry will take, again, normally a matter of days or weeks to register them. So if you want a quick registration
That's
because you're worried that's the route to take.
I see. And then you could add the other protection on at a later date.
You can within a sort of 6-month period, but it's most cost effective to do it up front. I would say so. It's better to plan ahead and try and do it all in one go. The other thing with designs to say is, as well as these registrations of designs, there is an automatic right you get by just creating a new design. It's a bit like copyright. If you were to paint a painting or to write a book, you automatically get copyright protection. For designs, you automatically get what's called unregistered design right. And this is quite complicated, but there's 2 versions of that. There's UK unregistered design right, which normally lasts for 10 years, and there's been an EU unregistered design right, which lasts for 3 years. And the way you qualify for those is slightly different, and the way they work is slightly different. In leaving the EU, we've left that option to get the automatic 3-year protection for under this EU design right, but the UK government has basically copied over the sort of equivalent of that. So if you generate a new design for ultimately for a sort of 3D product or something like that, you will get the UK unregistered design right for 10 years, and you would also get the kind of equivalent of this EU unregistered design right for 3 years, and it covers slightly more stuff. It covers 2D designs, which the UK unregistered design right doesn't do. So, you know, I would always advise that if you've got an important design, don't rely on unregistered rights, get it registered. But if you don't, then all is not lost, and we can look at whether if somebody copies your design, that's an option to look at.
There is still an element of protection at that point.
There is still an element of protection, yeah.
So with the benefit of cut and paste, I think to summarise that part of the conversation, the protection is still there. There's a little bit more work now that you have to register both in the UK and the Europe, which inevitably leads to an increase in costs as well. So firms have to be aware of that. But Withers and Rogers are well placed to deal with both aspects of those registrations.
That's right. Yeah.
When it comes to infringements, have there been many changes or things that firms should be aware of when actually applying for a patent infringement?
So for patents, really nothing has changed, because again, take a scenario where you've got yourself this European patent and you brought it into force in, say, the UK, France and Germany. They're the 3 most popular places that people tend to get the protection because they're the biggest economies in Europe. And you detect an infringement in Germany for the sake of argument, then to enforce your patent, you've got to go to the German courts and go through the process in the German courts. Nothing has changed really as far as that's concerned. Where it will change is with trademarks and designs. If the infringement is in the EU, you've got to have the EU right in the first place, and then you've got to go to an EU court to take that action. Whereas if the infringement is in the UK, then you've got to have the UK right in place to enforce the UK trademark or the UK design, and then the action has to be taken in the UK courts. And similarly, if you wanted to sort of invalidate, show that a trademark isn't valid or a design isn't valid, then you've got to do that through the relevant EU courts or a UK court if it's a UK right. For trademarks, there are some issues around usage. So if you don't use a trademark for 5 years, it becomes susceptible to being cancelled off the register because it's not being used. Around the world, the view's taken that you shouldn't have registrations cluttering up the registers if they're not actually actively being used. So For if you've got an EU registration and your usage has only been in the UK, then that would have been enough, obviously, up until the end of the transition period. Now you've got to go forward and think about, okay, well, if I want to keep my EU registration, then I need to be doing some active usage of that brand, that name in the EU. Otherwise, it could get taken off the register and other people could grab it.
That makes sense. And when you say not being used, is it the business's responsibility to prove that it is being used, or is the default position that it will drop off after 5 years?
So it will sit there until somebody, say, wants to register the same mark for a similar range of goods or services, and then what they might do is apply to the EU Trademark Registry to have it cancelled because it's not being used, and then the onus is on the owner of the registration to say, well, actually, here's my German distributor that's been using this trademark to sell my goods in Germany. You know, here's evidence of sales, etc., 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 that show that it has actually been used, and the mark shouldn't be cancelled. So that's kind of the process. So it will stay there. You can keep paying the fees until somebody else becomes interested in wanting to have it, basically.
Interested in that name, yes.
Yeah.
Well, there's been some very valid points you've made this morning, Paul, and I'm sure people watching this will find it interesting and may need to may wish to find out more. So obviously, Paul's available to have those consultations on a one-to-one basis, and the links will be provided on our website if you do want to get in touch with Paul.
Yep, we're always happy to have a kind of free initial chat to understand what the issues are and see if there's any way that we can help.
Which I'm sure, hopefully, many people will take up and make sure that their wonderful ideas are protected, appropriately protected in whatever territory they wish to sell it. So, Paul, it remains for me to just thank you very much for your time and your input on this conversation. And as I say, anyone that wants to take that further with Paul or his colleagues, please use the information that's provided.
Pleasure. Thank you very much.
Thanks very much.